held its mini conference and came up with a resolution calling on the president to revoke the suspension of the Chief Justice, Justice Gertrude Tokono, and also on the administrative call by the acting Chief Justice to withdraw his directive on filing and fixing of dates for new cases. This afternoon, this press conference will be addressed by the president of LINSOD, Eric Delano Alipo. And I believe a number of you already have his telephone numbers should you need to continue with any discussion. My name is Theophilus Jimega Jr. I'm also a lawyer. I'm the secretary to LINSOD. And I'll give you my number after the presser. And if you want to have further discussion, interviews, we are available. We have a number of our colleagues also available to speak to you in other Ghanaian languages, Twi, Ewe, Gan, etc. Without much ado, I'll leave the occasion for my senior, Eric Delano Alipo, to address the press. Thank you.
Thank you very much, Secretary. So, good afternoon, ladies and gentlemen of the press. We are grateful for your massive response to our call this afternoon, even though our invitation to you was at a very short notice. We have invited you here this afternoon. We who have invited you are Ghanaian lawyers and also members of the Ghana Bar Association, but have grouped together as a legal sector civil society organization, if you like, called Lawyers in Search of Democracy, LINSOD. Our name reflects our purpose and goal of ensuring that we make objective and meaningful suggestions to our governments to assist them in upholding the rule of law and proper democratic tenets in Ghana. We have invited you here this afternoon for you to listen to our reaction to the Ghana Bar Association's resolution made at a mini bar conference held on April 26, 2025, and published just yesterday, calling on President John Dramani Mahama to revoke his suspension of the Chief Justice, Ladyship Gertrude Araba Saba Tokono, in a constitutional removal investigation of the Chief Justice, and for you to carry a message to the general public of Ghana. Ladies and gentlemen, you will recall that in the last few weeks, our country has been going through a challenging constitutional process of having to deal with 3 petitions submitted by some citizens against the Chief Justice of the Republic and for her removal from office on grounds of stated misbehavior and incompetence. It is important to know that in accordance with Article 1466 of the Constitution of Ghana 1992 and the Supreme Court decision in Frank Ajay-Chum versus Attorney General and Bright Akwete in 2006, when President John Dramani Mahama received the petitions, he duly consulted with the Council of State and forwarded the petitions to the Chief Justice, Mrs. Tokono, to enable her provide her initial response in order for the President and the Council of State to proceed to review the petitions and determine whether or not the petition is a prima facie case against the Chief Justice. A couple of weeks later, after the Chief Justice's response had been duly submitted to the President, it was announced that the President, in consultation with the Council of State, had established a prima facie case against the Chief Justice, and subsequently, in accordance with Article 1466, the President, in consultation with the Council of State, established a committee to inquire into the petitions and make recommendations to the President. Consequently, as dictated by Article 14610A of the Constitution, the President, by a warrant and with the advice of the Council of State, suspended the Chief Justice pending the committee's investigations of the allegations made against her and did expected recommendations to the President. Upon close observation of the unfolding constitutional process in Article 146 for the removal of justices of the Superior Court, and in particular the removal of Chief Justice, Mrs. Tokonu, we of LINSOD cannot help but have tremendous admiration for His Excellency President John Dramani Mahama for his total adherence to due process and for upholding the tenets of the rule of law and constitutionalism. Indeed, it was no wonder when on April 24, 2025, the Ghana Bar Association had released a cautious statement that found no fault with how President Mahama was proceeding with the process and only advised him and all the players in the process to continue to uphold the principles of the Constitution. In fact, throughout the process until yesterday, the only notable persons or organization that was unhappy and had on Saturday, April 26, 2025, we heard of a purported resolution of the Ghana Bar Association passed by less than 50 members of the over 8,000 lawyers in Ghana, condemning how President Mahama had handled the process of the removal of the Chief Justice so far and calling on the President to revoke his suspension of the Chief Justice. The said resolution was later published yesterday, April 29, 2025. Upon reading the said resolution, we noted with disdain and utter shock the double positions taken by the Ghana Bar Association on the processes for the removal of the Chief Justice in their publications of April 24th and April 29th. The Bar Association has depicted abject double standards in the matter, and it is very shameful. Sadly, our vivid report from the mini bar conference indicated to us that a few MPP elements within the Bar Association who were unhappy that the earlier statement issued by the association did not support the NPP's position on the removal of the Chief Justice had hijacked proceedings at the meeting, argued relentlessly with some executives, stampeded everyone, and pressured the executives of the association into voting on a resolution to unjustly condemn President John Mahama for no fault. The Bar executives regrettably succumbed to the pressure and allowed the unthinkable to happen. The baseless resolution was therefore ignominiously, that's a big word, procured, thereby exposing the association to ridicule, considering its earlier statement of April 24, 2025. It is noteworthy that the two main grounds upon which the Ghana Bar Association sought to criticize President John Dramani Mahama in the process were namely, first, that his suspension of the Chief Justice was an exercise of a discretionary power provided for in Article 296 of the Constitution, and for that matter, it should have been exercised in a particular manner, which the President did not do. Secondly, that the proceedings and decisions of establishing a prima facie case against the Chief Justice was shrouded in secrecy and must be released in consonance with some twisted precedents and in accordance with principles of transparency and fairness. We shall discuss the two intents. In the case of the suspension of the Chief Justice, the President acted in accordance with Article 146(10)(a), which provides that the President may do so if he is advised by the state. The argument of the NPP and the Ghana Bar Association is that since the Article 146(10)(a) provides that the President may but not shall, it is a discretionary power. Article 296 of the Constitution deals with the exercise of discretionary powers, emphasizing that such powers must not be arbitrary, capricious, or biased. The Article 296C also requires the publication of regulations to govern the exercise of these powers when the person or authority exercising the power is not a judge or other judicial officer. The pertinent question here is whether the exercise of every discretionary power under our Constitution and in the governance of the country must be preceded by the publication of regulations that have been provided for by Article 296C. But fortunately, this matter was properly litigated in the past and was well settled by the Supreme Court and is well known to all the executives in the Ghana Bar Association, including the powerful MPP elements within that the court has settled it that it is never the case that the exercise of all discretionary powers must be consistent with Article 296C. In fact, the Supreme Court unanimously held further in Ransford, France versus Electoral Commission in 2012 that Article 296C applies to quasi-judicial situations only and does not apply to administrative acts such as the suspension of a Chief Justice. In the case of Eli Plim Agbemava versus Attorney General and Alfred Chua Yeboah versus Attorney General and Nana Asante Bediato versus Attorney General, this is consolidated cases, the Supreme Court reasoned that having regard to the wide executive powers conferred on the president by the Constitution, it would be literally impossible to function if he would have to go to Parliament with an instrument to guide him each time he wants to exercise a discretionary power. In addition to this, in the particular case, Article 14610A provides clearly that the president may suspend the Chief Justice only with the advice of the Council of State. The MPP and the Ghana Bar Association can accuse the president of acting arbitrarily and capriciously only if they can establish that the president acted without the advice of the Council of State. Ladies and gentlemen of the press, may I ask you, in the absence of the above reasoning, can you imagine the number of legislative and constitutional instruments or regulations the president would be required to publish on a daily basis before he exercises his discretion? On the Bar Association's request on the president to disclose to the general public the proceedings from which a prima facie case was established against the Chief Justice while the removal process is ongoing, we are certain that the Bar Association only wants the president to be lawless and go against the contents of the association's own statement of April 24, 2025. We find ridiculous as it is contrary to well-established procedure in the Ajechum case and therefore demeaning and terribly offensive to the basic tenets of democracy. The so-called precedents the Bar Association has in mind do not support the call the association is making on President Mahama. In fact, in all of them, the decision only becomes public when the process is either terminated, as in the case of the petition by Professor Stephen Kweku Asare against the Chief Justice in 2024, or completed, as in the case of Madame Charlotte Osei in 2018. In the present instance, the process is still ongoing and promising to proceed to its logical conclusion. Until then, the decision or proceedings cannot be made public as being demanded by the Ghana Bar Association. Of course, the finding of a prima facie case against the Chief Justice and her suspension are in no way a pronouncement of guilt. It is therefore out of this simple constitutional provision. In fact, though it still remains an answer to be held, require the determination to be made public. We therefore state unequivocally that there is no legal obligation on the president to publicly disclose what the Bar Association is requesting when the process is still ongoing. The Ghana Bar Association cannot force the president by a resolution to act contrary to the law. Ladies and gentlemen of the press, the Ghana Bar Association's so-called resolution touches on a few other subjects, such as cautioning its members against prejudicial comments on the process for removal of the Chief Justice while the process is still ongoing. Regrettably, the association's own conduct is tantamount to making prejudicial comments on an ongoing investigative process, and it might as well abide by its own advice. The other subject, a call on the acting Chief Justice to withdraw a directive he had given for new cases to be forwarded to his office for assignment of dates and courts as the case may be. We are totally surprised by this call because these are administrative functions of the Chief Justice. Per Article 125(4) of the Constitution in 1992, the Chief Justice is the head of the judiciary with the responsibility of the administration and supervision of the judiciary. The directive by the acting Chief Justice falls squarely within his administrative remit. Ironically, the suspended Chief Justice had overly engaged in these activities, including issuing a directive on July 28, 2023 to suspend the electronic case distribution system. The Ghana Bar Association was deeply asleep at the time and did not even notice it. We of LINSOD, who are also members of the Ghana Bar Association, wish to state emphatically that we are appalled by the association's tradition of double standards, posturing, and bias against NDC regimes. In the past 8 years of Nana Akufo-Addo's MPP regime, the regime's thugs had invaded a courtroom in Kumasi and frightened a pregnant judge who was shepherded out of the courtroom. The chairperson of the Electoral Commission was removed. An Auditor General was unconstitutionally removed from office. Public demonstrations were stifled by judicial processes and high-handedness of security agencies. 4 major traditional areas were denied of representation in Parliament for a full term. NPP thugs in security uniforms had attacked citizens and slapped a member of Parliament. Judges were transferred in the middle of cases they were presiding over. Accused persons were denied bail for donkey years. Supreme Court panels were changed in the middle of hearings. Some members of the Bar Association were harassed by the General Legal Counsel, and many more infringements of the Constitution. In all of this, the Ghana Bar Association was in deep slumber or was purposefully blind. It is shameful that the Bar Association has now only found its voice again when another NDC government is in place. If the Ghana Bar Association is interested in knowing exactly how many of its members feel, then we wish to inform the leadership of the association that many of us members who are not affiliated to the MPP feel strongly that the association has allowed itself to be used as a tool by MPP for a very long time to harass NDC regimes and activists. Gone were the days when there were only a few lawyers and most of them were MPP activists and executives. Today, we are many and of different political backgrounds, and we are tired of the association's partisanship tendencies. If the Bar Association decides to keep us united, then it is important for its leadership to shed itself off the MPP collaboration and turn a new leaf and be there for all of us. If all lawyers of Ghana must remain united and have confidence in the Bar Association, the association must make a U-turn from its age-old trajectory of being a tool for the MPP. We wish to remind the Ghana Bar Association that it is only an association of voluntary members of the bar, and these decisions are binding only on its members, but do not bind non-members, and certainly not the President of the Republic of Ghana. The Ghana Bar Association must therefore not attempt to stampede President Mahama, who is performing his constitutional duties very admirably. It is instructive to note that the President is strictly complying with the provisions of Article 146 and also guided by the same process the former President Nana Akufo-Addo used in the removal of the former chairperson of the Electoral Commission, Madam Charlotte Osei, in the year 2018. In conclusion, the Ghana Bar Association, in their resolution, has not demonstrated any evidence of procedural impropriety, bias, arbitrariness, or unfairness in the suspension of the Chief Justice to warrant its call on the President to revoke the suspension. We therefore wish to restate that we find the association's resolution ignominiously procured, and we call on the President of the Republic to ignore the said resolution as one of the many small noises of the NPP and East Ghana Bar Association affiliate. The law is the law, and the Ghana Bar Association must not prescribe anything else other than the law. It must rather adhere to its statement issued on April 24, 2025, which had urged all the players in the process to continue to uphold the Constitution of Ghana. We are grateful for your presence and association with us. Long live the Constitution of Ghana. Long live LINSOD. Long live the Ghana Bar Association. Thank you very much for coming.
Thank you, Mr. President. We'll take some questions and any concerns or comments. From the name and
I'm Peter. Wow, I work with GH1.
GH1.
Yes. My question is, Ghanaians were made to understand that this is a mid-year national conference of Ghana Bar Association, and you are members of Ghana Bar Association. We want to find out why you fail to attend that meeting to also make your input during the conversation or during the debate over this market. Is it the case that you are aware of what is going to happen when you recruit yourself from the meeting, or the meeting was organized by some members of you without including you who they know to be neutral, so to say?
How do we do it? Do we take the questions and answer them? Five. Okay.
My name is Charles Ozukumi. I work with CTFM. I know you mentioned that the president cannot go to parliament for an instrument every time he wants to exercise the discretionary power. But with a matter as important as the suspension of the head of another arm of government, don't you think that 296 must apply?
And let me add up to my question again, and top up to my question, my earlier question. So, in every association or in every organization, there is something called quorum to make important decisions. In your presentation, you mentioned that 50 or 500 or 50 50%, less than 50%. But okay, less than 50 members attended that meeting. In Ghana Bar Association, don't we have this cross that says that before a major decision is taken, members in good standing must be present in a certain number, more than half or more than 2/3, as in parliament cases, to make a decision. And if it is so, what action can you take against your group for violating your laid down procedures? Any other?
Can we take one more, please? Okay, we can respond to this. I will address a number of them, and the president can come. I take it first from Charles Owusu Kumi from CTFM. You mentioned the fact that the president mentioned the presser that it is not every matter for which the president of the republic has to go to parliament to obtain a CI before taking discretionary decision. And with a matter such as important as this, why wouldn't the president have gone to parliament to get that? One, there is the idea of safeguard within the power of the president to take this measure. That is why it says that the president, in consultation and upon advice of the Council of State. So the fear that you have that the president might take any arbitrary decision is already catered for within the clause that says upon advice and in consultation. And indeed, in a number of there's a Supreme Court decision that says that the president is not bound by the advice, but cannot go beyond the advice. So it beats my mind, or it goes to say that the president acting upon advice and in consultation means he's acting within the advice that he was given. How can you imagine, as we said, how the country will look like if at every Tom, Dick, Harry discretionary duty the president has to perform, he has to write to parliament? The country will come to a halt. And there is a Supreme Court decision, or there are two Supreme Court decisions that we are following. So in that particular instance of the 296, the president has not faulted or has not been found wanting. In any case, if the Ghana Bar Association feels that the president is acting without or outside the law, lawyers as we are, we know what to do. We go to court. It is not upon a resolution for which we need to say that the president was acting outside the remit of the law. Now, you also said an issue as important as this. I believe every decision taken by the president is a very important one. The president does not take trifle decisions or decisions on trifle. That is to say, very minimal things. No, the president takes very important decisions. So there is no decision the president will take on an issue which is not important to the president. You also, that is for Peter Kwao. Okay, Senior wants to add something.
Sometimes when you want to push an agenda through, you end up slaughtering common sense. This is exactly what the Ghana Bar Association has done. And additionally, a matter or petition which is supposed to be carried out in secrecy, if you go to parliament, is it not the same as going to Makola to announce to Makola and those who go there to buy that day and to then send the whole world that this is what is happening? So you see, a discretion which is properly exercised on the basis of keeping this matter shrouded in secrecy until fully determined, Ghana Bar Association is slaughtering common sense, or has slaughtered common sense, and asking that the petition should not be shrouded in secrecy any longer. I think that should be the reason why GEM exercised that discretion reasonably, by not even going to parliament to lay out an ally, because that will, give out or expose the petitioners and everything which the law is trying to protect. Okay.
Now, thank you, Senior. Peter Kwa from GH1, you asked the question that Ghanaians were made to understand that this was a mid-year conference. You would have noticed that last year there was no mid-year conference. The year before, there was no mid-year conference. The mid-year conference used to exist until somehow they disappeared and they are coming back. The way the mid-year conference came back this year is one that is a bit shocking. Now, to address your issue, members of the bar were entitled to 21 days notice before the conference is held. This particular one didn't get 21 days notice. Now, number of members of the bar are still complaining that they have not even received any notice. Suffice it to say that once you publish it, it is assumed that everybody will have it. However, we receive individual text messages, individual emails of GBA notification. So for the first part was that the notice period was even so short for anybody to organize and be at such a program. So that is number one. So we of LINSOD are saying that if you are holding people onto a certain level of doing the right thing, then GBA do the right thing. Indeed, Non-lawyers can equally tell you today that he who comes to equity must do equity. So you cannot go without doing equity and be shouting for equity. Number two, you ask whether a forum has been formed. The lawyers will say the thing speaks for itself. You mentioned that there are over 5,000 to 8,000 lawyers in Ghana, and if 43 of them are saying yes, 4 abstain, and the number of them didn't vote, that will not in any way get closer to any number that will be envisaged by anybody as being quorum. So that thing speaks for itself. You also ask, what actions are we going to take about the GBA? The first action is what we are doing today. We want Ghanaians to know GBA is just like GPRTU, like NAT, like NAGRAT. Like GBA is not an extension of any statutory body. Indeed, GBA is mentioned in the Constitution in a number of places. But I can assure you that when the Constitution is reviewed, it will no more feature GBA, it will feature law associations or a law association, so that tomorrow, if someone has a law association, they will also feature. And let me use this opportunity to tell you that there is Law Society of Ghana, which is also in existence. And just as previously we used to have NAT, and we came NAGRAT, and came Consent Teachers Association. When you were young, I believe we have only GPRTU. Now we have ProTour. We have, you know them, we have a lot of them. I am not saying GBA is splitting, but this is the first step. We are taking GBA on to let GBA know, and the whole world know that what was done on Saturday, the double standard cannot go on. Number two, you ask whether we'll take them on further. Yes, we are exploring all the avenues available to us. But the bigger picture is, what does GBA want to achieve? The GBA wants to say the president should suspend the suspension of the suspended Chief Justice. That we believe will not happen. We are advising the president to consider it as one of the small noises that is being made by certain elements of GBA. Equally, we want to say that the GBA has directed, as Senior said, the Chief Justice to withdraw his administrative duty. Another thing, we are reminding GBA that when Madam Tokonu did it previously, GBA was quiet. Let me use this opportunity to say, in 2022, when we were at the Bar Conference in Hope, the Chief Justice, acting Chief Justice then, Justice Jones Doche, admonished the GBA to wake up and speak on national issues because they have been asleep for so long. What happened that all of a sudden GBA is up, and not up yet to wash their face? They are up already and talking. I leave that one to you.
So let me ask you this question. I just want to know if you think that there's some influence, let me say political influence, in this call made by the GBA, because we know who the president is. So I'm just asking, I want to listen.
Any other question? Where are you?
Metro T.
Yes, my name is Osman. I just want to find out how did the Supreme Court pass ruling on constitutional matters? How did they influence this particular case?
How the past one?
Yes.
Yes.
On constitutional matters.
Osman, we operate what we know as the common law jurisprudence. So the common law says that don't wake something which has been settled already. We call it stare decisis. One is has been settled, pick it and apply it. Now, we have indicated a number of cases where people have gone to court to ask the Supreme Court to say that the president, without publishing a constitutional instrument, cannot exercise such a discretion. And the Supreme Court says that if such a thing is allowed to happen, it will lead to a nuclear meltdown. That the president every morning will wake up, because the president takes discretionary decision every day. and the president will wake up every day and go to parliament to get a discretionary decision, a CI published, come back and take the decisions. That will not happen. Now, that is why we find it a bit odd that as lawyers, we should be aware of such decided cases from the Supreme Court. If we are today acting as if we are defending the Supreme Court, then we should be in position to be able to defend what the Supreme Court has said and use it properly. We should not be the ones trying to act unlawfully whilst asking someone to act lawfully. So the decided cases should be able to guide us. Now, we said in our statement that we commend JM for the effort so far. If you notice, this is something for which, apart from certain elements within MPP, whose voices have even gone down, nobody is complaining about the process. Everybody appears to be, this is the process, let's go according to it. And again, let me warn you, please, if you hear lawyers speaking sociology and theology, and they are not talking law, then there's a problem. They are not talking law, but they are talking about you have to forgive, it can happen to somebody, it might not happen to somebody. No, let's talk law. They've not said of any law that JM has breached. So the previous cases are supposed to be guides, and they are supposed to be passed. We just slot in and move on. We are no more going to bring a new wheel now to reinvent. No, that's not going to happen. Then you also ask, sir, whether there is a political influence in this action. I think that we cannot hide from the fact that, as we stated here, that GBA at a stage has become an appendage of a political party, specifically the MPP. And we stated in our release here, that, or in our address here, that GBA must be aware that times have changed. There are several lawyers now with different political backgrounds. So the days where some people hijack the GBA and use it to achieve a particular interest are gone. Let us have a broad consultation on things that we do. Indeed, if you follow social media landscape from last night to today, the GBA is being ridiculed. Let's be honest with ourselves. Several posts describing GBA in different ways that I cannot repeat here. I'm a member. And some of those posts would have been needless if we had stuck to the release that was made by GBA on April 24th, 2025. We cannot for certain say, we cannot say that because the GBA president is the wife of Joe Gatti, that is why certain things are happening. But we are aware that part of the actions at the mini conference was heralded by activities of the MPP, and they organized their people to attend in massive numbers. Unfortunately, they couldn't get the massive numbers that they expected. And let me tell you one of the things that happened at the conference. When the president and the executive said they cannot issue a statement to condemn the JM for suspending the Chief Justice, they turned out to say if you cannot condemn, then issue statement to commend him, which they know the association cannot do. And it was a to and fro that led to someone saying, let's vote and to see if we can get a resolution. That is what happened at the conference.
Additionally, the question was whether there is a political influence. Obviously, yes. I mean, judging from what happened at the last bar conference in Kumasi, I was there. The past Attorney General was going around campaigning for the president-elect, and money was flowing all over the place. Lawyers who are honest to themselves will concede or accept that without this were paid, monies were given to them for their transportation, they were given per diem, and all others in order to influence their voting party. I was terribly frightened at the bar conference in September in Kumasi because I was telling myself, and I'm saying it again, if lawyers, very, very intelligent people, can be influenced by money to vote in a particular way, then this country is doomed. and I didn't even know that the results of the 2024 election will go the way it did. It means that it has given me the assurance that greater number of Ghanaians have conscience and they will not be influenced by money, unlike what the lawyers did in Kumasi.
President want to add.
Let me just add to the two questions that we asked. The first question that came from you asked whether there was any political influence. I think that was very clear in our statement. We didn't hide it at all. We stated clearly that NPP elements had stampeded the executive and they forced them into taking the resolution, to voting for the resolution. See, because they had planned and went for the conference. See, so they knew they were going to do that, and so they got their people. Because this is just a mini bar conference. You would even see the number. I heard the PR of the bar association say that at the beginning of the conference there were about 200 members, and then when it got to the time to pass the resolution, there were just about 50 or so, because it was 43-4. So 50, even 200 out of 5,000. So you will see that if there's a very important, crucial decision to take by the bar association, it shouldn't be at a mini conference. It means that people do not pay attention to the mini conference as such. But clearly our statement, and some of you will have copies if you ask for, you will see that we didn't hide that at all. We are very honest.
And to,
then,
sorry, Senior, to add to it, there is a method of passing resolution. The resolution must have been submitted to the Secretariat at least 30 days before the conference, and that didn't happen yet.
Then the question by the representative of Radio Board as to how the previous decision of the Supreme Court, what we call the precedents, how they influence. See, we have to respect precedents, decisions that are made by the court. You see, that is why some of us, we are concerned if the courts are not honest. You see, because the courts will have a predetermined position on certain things, and then they make a decision which will be baseless or which will not stand the test of time. But once they make the decision, once the decision is coming from the High Court, if I say High Court in this case, maybe the highest court, the Supreme Court, it becomes law. So that is there. If you, again, not to confuse you, you see, this Article 146, removal of justices, the situation really in the Constitution is that if it comes to the removal of justices other than the Chief Justice, the Constitution is very clear that there will be a prima facie establishment of a prima facie case. It means that when the petition comes to the President, he has to send the petition straight away to the Chief Justice. And the Chief Justice will make a determination if there's a prima facie case before a committee will be formed. But in the case of the removal of the Chief Justice, which is in Article 146.6, there's no requirement for prima facie case. At all. It just says that when the President receives a petition, and I believe that the framers, they knew why they did it so. When you receive a petition, don't toy with the petition. Together with the Council of State, just form a committee, refer the petition to the committee, and then the Chief Justice can go there with any number of lawyers to defend himself or herself. But there was a case in court, and then the Supreme Court said that, well, once there was a requirement for the determination of prima facie for removal of other justices, we shall also add that also to the requirement for the removal of the Chief Justice. That is the J2 case that we are talking about. And so when you still open the Constitution as of today, Article 146.6, there's nothing about prima facie case at all. But the prima facie case, in the case of removal of Chief Justice, is only in the J2 case, not as a text in the Constitution. You see, but you will see, so when this issue came out the first time, some of us, we argued that, look, we should just stick to the text of the Constitution. But, you know, President Mahama went by the advice his legal advisors gave him, and I think that is okay. Because if he had gone by my way, they would have been challenging it in the Supreme Court right now. But because the Ejectum says that release the petition to the Chief Justice and get the Chief Justice's comment before you establish prima facie case, he did all of that, although the Constitution doesn't say so. That is how much they respected the precedent, the Ejectum case. And that is how we also expect that the Ghana Bar Association will respect the case that established that it is not in every exercise of discretionary power that the Article 296C has to apply. They have to respect that. Thank you.
Please, I'm Daniela from UTV. This is not the question, it's a plea. We want you to please summarize this issue so that the local listeners and viewers can also
Any other question? In case you want to.
Sure. I am not breaking to check in.
Let's finish. I want to.